This is a continuation of the previous topics that we've had on dispute resolution and crisis management. So it's very important that we know the difference between ad hoc mediation and institutional mediation. So when we say ad hoc mediation is one where the parameters of a mediation set by the parties are only for the particular dispute, whereas institutional mediation is one where the parties refer their dispute to an institution of mediators and agree to be bound by the rules of such institution. So when we say ad hoc mediation, this is an alternative dispute resolution wherein it's more flexible and cheaper for the reason that the parties do the arrangement. And it is not basically administered by any institution who does alternative dispute resolution, and there are no admin fees on this. So this is suitable for small claims, small issues about parties. And when we say institutional mediation, is one where the parties refer their dispute to an institution of mediators and agree to be bound by the rules of such institution. So in institutional mediation, there is an institution wherein they have a list of qualified mediators. And this institutional mediation, there is already an established process on how to handle disputes. Whereas for ad hoc, it is just basically the parties who will do the arrangement. So we have here court-annexed mediation versus court-referred mediation. So court-annexed mediation, it means any mediation process conducted under the auspices of a court and in accordance with Supreme Court approved guidelines after such court has acquired jurisdiction of a dispute. Court-referred mediation means mediation ordered by a court to be conducted in accordance with the agreement of the parties when an action is prematurely commenced in violation of the agreement. So court-annexed mediation, if we try to compare it with court-referred, in court-annexed, there is no agreement that's happening first between the two parties. So basically, there is no arbitration clause that happened in court-annexed. So if ever they would file the case to the court has the authority to order both parties to undergo mediation first before they would file the case to the court. Whereas court-referred mediation, this is a mediation wherein the agreement happened first. There is an agreement between two parties and there is an arbitration clause on the contract, any document wherein if one of the parties violated, they need to seek mediation first before filing it to the court. So just to summarize, we say court-annexed, there is no agreement that is happening first. There is no arbitration agreement or clause. So the court here will order both parties to undergo alternative dispute, specifically mediation. For court-referred, there is an agreement first. And once there is an arbitration clause wherein they need to undergo mediation, so the court will order them to have that mediation first before filing the case into the court. And these are some other terms to ponder. When I say certified mediator, this is a mediator who is certified by the OADR that have successfully completed the regular professional training program. The mediation party, these are persons or individuals who participates in the mediation process, and it's necessary that there is a consent coming from them. The mediator is the one who conducts the mediation, whereas when we say non-party participant, it means a person other than the mediator who participates in a mediation proceeding. So it could either be a witness, a resource person, or an expert. So when it comes to the selection of a mediator, the parties, both parties, they have the freedom to select who they want. So they can select on the roster coming from the OADR. And the parties may request the OADR to provide them with a list or roster or the resumes of its certified mediators. And the OADR may be requested to inform the mediator of his or her selection. And when it comes to the replacement of mediator, If the mediator selected is unable to act as such for any reason, it could be a personal reason, due to any other nature, the parties may, upon being informed of such fact, they select another mediator. And when it comes to the refusal or withdrawal of mediator, a mediator may refuse from acting as such, withdraw, or may be compelled to withdraw from the mediation proceeding with the following circumstances. If any of the parties, so it could be one of them, if they requested that the mediator be withdrawn from the proceedings, they can do so. And the mediator does not have the qualification. The mediator may refuse or withdraw from the proceedings. And if there is a question about impartiality, the mediator may be compelled to withdraw from the proceeding. If the continuation of a process would violate any ethical standard, if there's a question about competence like that, so the mediator may be compelled to withdraw or may refuse from proceeding with the mediation. And also if the safety of any of the parties would be jeopardized, that's another reason, and if the mediator is unable to provide effective services. And thus are the ethical conduct of a mediator. It's expected that the mediator should have this accepted behavior when in the performance of their duty as a mediator. So that is competence, impartiality, confidentiality, consent, and self-determination. So in competence, it is really not required that a mediator should have a special qualifications by background or profession unless the issue needs a special qualification. However, the certified mediator shall, of course, that mediator shall upgrade his or her professional competence in mediation skills. So there is a training program that is being given by the OADR, and that mediator shall also ensure qualifications, training, and experience are known to and accepted by the parties, and serve only when his or her qualifications, training, and experience enable him or her to meet the reasonable expectations of the parties. And upon request of a mediation party, an individual who is requested to serve the mediator shall disclose her qualifications to the parties. And when it comes to impartiality, a mediator shall be impartial. So before accepting a mediation, an individual who is requested to serve as a mediator shall make an inquiry. So this is a requirement wherein it emphasizes the importance of proactive steps by the mediator to identify and address any factors that may compromise their impartiality. So the purpose of this inquiry is to maintain transparency and openness in the mediation process. So both parties should be aware of any potential conflicts or connections that could impact the mediator's ability to facilitate a fair resolution. And also, the mediator should disclose to the mediation parties any such fact known or learned. And when it comes to confidentiality, it's one of the ethical standard that should be done, by the mediator. So a mediator shall keep in utmost confidence all confidential information obtained in the course of the mediation process, whether it is written or oral. It should not be disclosed. Consent and self-determination is another ethical conduct that should be abided by the mediator. So a mediator shall make reasonable efforts to ensure that each party understands the nature and character of the mediation proceedings. So next one is the mediator shall recognize and put in mind that the primary responsibility of resolving a dispute and the shaping of a voluntary and uncoerced settlement rests with the parties. So the mediator must really be determined that there should be harmony when it comes to settling the dispute. So the mediator should really ensure that. And when it comes to the place of mediation, The parties are free to agree on the place of mediation, and failing such agreement, the place of mediation shall be convenient and appropriate to all parties. So that is one of the freedom of the parties. It's to choose the venue or place on where the mediation would happen. So when it comes to the fees and costs, especially if it's an ad hoc mediation, which is flexible, cheaper than the institutional mediation, the parties are free to make their own arrangement as to the mediation cost and fees. So in default thereof, the schedule of costs and fees that is to be approved by the OADR. And when it comes to the institutional mediation, there is administrative charges that will be paid by the parties. And aside from that, there is a mediation fee that will be paid by parties. And that is based on the complexity of the case, the number of hours spent in mediation, as well as the training experience and stature of the mediators. So here comes the international and domestic arbitration in the Philippines. So our international and domestic commercial arbitrations are primarily governed by RA 9285 as well as RA 876. And we based it on the model law, which is given by the UNCITRAL. So UNCITRAL model law, we adapt it. So it is designed to assist states in reforming and modernizing their laws and arbitral procedure. So our country is adapting that one whenever we try to settle disputes. Then we have here international arbitration. It's an arbitration where parties to an arbitration agreement have at the time of the conclusion of that agreement their places of business in different states, or one of the following places is situated outside the Philippines, which the parties have their places of business wherein. So if there are disputes wherein one of the parties is settling or situated outside of the Philippines, then it needs an international arbitration. And we have here the following important terms to consider as well. What is a non-convention awards? It's a foreign arbitral award made in a state which is not a convention state. When we say non-convention state, those are states which is not a member of a New York Convention. So we've discussed that previously. What is a New York Convention? And we have the appointing authority. It refers to person or institution named in the arbitration agreement as the appointing authority, or it refers to regular arbitration institution under whose rules the arbitration is agreed to be conducted. And we have the arbitral tribunal, so it's a sole arbitrator or a panel of arbitrators. And when we say commercial arbitration, it's an arbitration that covers matters involving relationships which is commercial in nature. And also, when I say convention award, a foreign arbitral award made in a convention state. So basically, when I say convention state, those are states that are part of the New York Convention. Court also refers to a body or organ of the judicial system of the Philippines. We have the RTC, CA, Supreme Court, and so on. And domestic arbitration, an arbitration that is not international. So ad hoc arbitration, an arbitration administered by an arbitrator and or the parties themselves. And arbitration administered by an institution shall be regarded as an ad hoc if they are not certified here in the Philippines. So ad hoc arbitration, basically the one who makes arrangement are the parties as well as the arbitrator. Yeah, so these are one of the organizations that would help when it comes to dispute resolution. We have the PDRCI, the Philippine Dispute Resolution Center Incorporated. We have the PICCR, the Philippine International Center for Conflict Resolution. And also the Philippines has specialized arbitration bodies that deal with the resolution of disputes arising from specific industries. We have the CIAC. So it's a main arbitration machinery for construction disputes, which is covered by arbitration agreements. And for domestic arbitration, these are some terms to ponder. So the appointing authority, if it is an ad hoc arbitration, if in case there is an absence of an agreement, the national president of the Integrated Bar of the Philippines or any of his duly authorized representative can be the appointing authority for ad hoc arbitration. And appointing authority guidelines, these are a set of rules approved or adopted by an appointing authority for the making of a request for appointment, and so on. And arbitral tribunal, this refers to sole arbitrator or a panel board or committee of arbitrators. The claimant, a person with a claim against another, and who commences arbitration against the latter. And court refers to here as a regional trial court, unless it is otherwise specified in the rules. Day means calendar day. So domestic arbitration, an arbitration that is not international in nature. So here is the law governing domestic arbitration that is stated on Section 32 of RA 9285. The domestic arbitration shall continue to be governed by RA 876 or the arbitration law. So when we say domestic arbitration, it is defined under RA 876 as arbitration that is not international. That is also defined in Article 2 of the model law, which we adopted. And we have here the other forms of alternative dispute resolution. So we have here early neutral evaluation. We've discussed that previously, but let me discuss it further. It is an ADR process wherein parties and their lawyers are brought together early in the pre-trial phase to present summaries of their cases and to receive a non-binding assessment by an experienced neutral person with expertise in the subject matter or substance of the dispute. So when say early neutral evaluation, you are presenting the case to an expert wherein you hear what is the opinion of that expert about the dispute, whether there would be a positive or negative outcome, just in case you're going to file the case into the court. And when we say mediation arbitration or med-arb, it's a two-step dispute resolution process that involves mediation first. After mediation, if the concern is still not resolved, then it is followed by the arbitration. Mini trial, on the other hand, yes, I've also discussed that previously. It's a structured dispute resolution method wherein you're going to present your case into a panel of senior decision makers. It's like a trial, however, it's informal in nature. So the senior decision makers are going to give their opinion about the dispute, and once they give their dispute, you will know what would be the outcome of the case, just in case you want to file it in the court. So mini trial, it's just like a trial. It's just that it's not the decision is not being given by the judge. And OADR, this is the office for alternative dispute resolution, which is an attached agency of the DOJ. So the law that created the OADR is the RA 9285. So its main mandate is to promote, develop, and expand the use of ADR in the private and public sectors of our country. And here are the powers of the OADR. It's to act as appointing authority of mediators, to conduct seminars, of course, and it's to establish an ADR library or resource center where ADR laws, rules, and regulations, jurisprudence, books, articles, and other information about ADR in the Philippines and elsewhere may be stored and accessed by people. And also, they establish a training program for ADR provider and practitioners, both in public, to certify those who have successfully completed a regular professional training programs provided by the OADR, to charge fees for services that they've rendered, to accept donations as well from local and foreign sources, and also to exercise such other powers that may be necessary to properly carry into effect the provisions of the ADR Act of 2004. Aside from that, their function is to promote, develop, and expand the use of ADR in private and public sectors, to monitor, study, and evaluate the use of ADR, to recommend to Congress needful statutory changes, to improve our ADR, to make studies on and provide linkages, to compile and publish a list of roster, and to compile a list or roster of foreign or international ADR provider and practitioners. So the OADR also have different divisions. They have the Secretariat, which shall provide necessary support and discharge such other functions and duties as may be directed by the Executive Director. We have the Public Information and Promotion Division, which shall be charged with the dissemination of information. And they have the Training Division, of course. This is a division that conducts with the formulation of effective standards for training of ADR practitioners. And they also have the Records and Library Division, which shall be charged with the establishment and maintenance of essential repository of ADR laws, rules, and regulation, and other information about ADR in the Philippines and elsewhere. So we have here the Advisory Council. So it's provided here on Rule 2. So Article 2.5, here are the composition of the Advisory Council. So it is composed of a mediation profession, there's also arbitration profession, as well as ADR organization and the integrated part of the Philippines, as well as those on the academe. So the members of the council shall be appointed by the Secretary of Justice upon the recommendation of the OADR Executive Director. And for Article 2.6, the role of the Advisory Council, it's to advise the Executive Director on policy, operational, and other relevant matters. So they would have a regular meeting at least once every 2 months or upon call by the Executive Director.